All right, Mr. Johnson. Right, you can come up here. As your attorney here, Mr. Ned.
He was here just a second ago. I don't know where he's going now.
All right, so wait for your lawyer, Mr. Ned, to come join us. And we've got, all right. All right, so we're on the record in docket 2402-995. That is People of the State of Michigan versus Antonio Johnson Jr. Will the parties please introduce themselves for the record? Mr. Staples.
Matt Staples on behalf of the city of Lansing.
Mr. Ned.
Thank you, Aaron. George and Ed, APD on behalf of my client standing to my right.
And sir, you are Antonio Johnson Jr., is that correct? All right, thank you. This is time set for deferred sentence on this matter. Looks like we set this in April for deferred sentence for today. Mr. Staples, how are we proceeding?
Your Honor, the defendant has not obtained a valid license. It's my understanding today that he would like to move forward on the underlying guilty plea. There would be an agreement between the parties to a sentence of fines and costs in this matter.
And is that a fair statement, Mr. Ned?
Yes, Your Honor.
All right, so this is D has not obtained compliance. This would be plea discharge to be driving while license suspended, which is a 90-day misdemeanor and or $500 fine. And my agreement is there's a kilobrew of fines and costs only, kilobrew no upfront jail. Is that correct?
Yes, Your Honor, since he's already pled, I don't know if technically it's a kilobrew, but yes, the agreement would be to no upfront jail.
All right, Mr. Ned, if you had the opportunity to speak to Mr. Johnson about the potential consequences of pleading to the charge.
Yes.
All right. Any allocution on this matter, Mr.
Yes, Your Honor. I spoke with my client this morning under the circumstances that we're not going to display on the record today because of open court. There's been a lot going on in regards to his child and his father. Currently residing in the Flint area, trying to take care of his family, trying to support financially. He's been looking for work. Under the circumstance, yes, Your Honor, I know he understands. He owes some fines and costs for some prior issues. He actually came today from Flint with 2 money orders to make a payment today as soon as we're done with court. We're just asking the court to follow fines and cost recommendation from the city, thankfully. So Mr. Johnson go about his life, take care of his children, take care of his father. He's asking for, if the court does follow the recommendation, at least 90 days, if not more, to make the payment as he owes money in Pontiac, a few here, and now whatever's going to happen today.
All right. Mr. Johnson, is there anything you'd like to say to the court before the court passes sentence?
Yes, sir. I'm just so surprised it's taking me so long to find a job. I wish you guys could see Flint do not have a lot of opportunities. Like when I was living here, I had a job. It was perfect. And I could have low key actually had the money paid right now. But since I had to move back, it's just been a little harder. I didn't think it was gonna take this long.
Okay, all right.
But sorry about that though.
Yep.
I'm trying. Only thing I can do now is really just donate plasma
Right.
until I get a job.
Well, and you have to prioritize. I understand that.
Yeah.
All right. So we'll set out. I'll follow the agreement, fines and costs only, and set fine at it'll be $400 in all. Fines and costs $400. Crime victims' rights fee of $75, state fee of $50, for a grand total of $525. And then it will be abstracted. The driving while suspended will be abstracted to the Secretary of State. And your client, Mr. Ned, you said your client needs about 90 days.
If the court's willing to give more, if he does need more time, I just don't know
Right.
what you can max out on.
When I refer to collections, yeah. So let's refer to all the collections. That way, it's all in one pocket.
Okay.
So you can just go to Marquita here for collections. We'll refer the whole matter to collections, and then you can kind of set up a plan as you go. All right, sir. All right. So it's referred to collections of $525. Mr. Johnson, you're all set. Thank you.
All right.
Yes. Setting up different. All right. we know we have Mr. Robu's case to complete. And then, so let's go on, let's do the 130s and we'll do some
Sure.
civil stuff.
Your Honor, do you mind if I set these? These are the official exhibits. I just don't want them.
All right,
If there's going to be other people about.
right. All right, so let's go on the record. Have to pull that up.
I'm on mute.
To be marked. 9, it would be for rebuttal. What? 9.
And can you tell me what it is? I don't have any questions.
Yeah, it's a lease.
Okay.
Step outside to warm up. Remember, I didn't have my key card.
All right, Mr. Lutz, we'll call your case. I have William Ken Lutz and Cheryl Lutz versus Cheryl Kosurik, docket 2502330. Appearances for the record, Mr. Lutz.
Yes, Your Honor. At our last June court ruling of the understanding that
First, sir, you're William Lutz?
yes, sir.
All right. All right. All right. My understanding of this case is that the case was dismissed because you didn't file an order to follow up indicating, because this came out of a hearing. That's my understanding. Because that's the last I read. I read the notes in this matter. And it appears that I signed an order of dismissal at the request of the civil department because let's see, found for plaintiff after hearing amount placed on record, plaintiff to submit an order to civil department for money judgment valid after hearing intended appeared and testify, order to be submitted by pro per plaintiff. So, and then I can only imagine they contacted me and said that an order had been submitted. So that's why the order of dismissal, this is to set aside the order of dismissal. Is that correct, Mr. Lutz?
Yes, Your Honor.
All right. So you understand that as a pro per plaintiff, you have to file an order of what I indicated at the hearing.
Oh, at the hearing?
Okay, Your Honor, it was my understanding that we were supposed to wait until she was finally out of the apartment so that the final
Amount.
money judgment could be summarized. And
I have money judgment valid after hearing and tenants appeared and testified, order to be submitted by pro per plaintiff. And then that's why we dismissed, because we thought that you'd worked everything out. And so I will grant your motion to set aside the dismissal, but you're still going to have to come to something. You're still going to have to come forward to file a motion as to what happened in the case, because the civil department was waiting from your direction as to you have to file something.
okay, so that means I have to come down and go to the civil, the desk there and file a motion there for an amount.
What you'll have to file an order indicating whatever's happened in the case. I had plaintiff to submit an order to civil department, money judgment valid after hearing, and tenant appeared and testified, order to be submitted by pro per plaintiff. So, and then I just don't remember, since this was in June 4th, I just don't remember the details of what the order was, but we can go back and listen to it. So we have it, it's on the record. We're gonna need an order to that effect, and nothing was submitted. So that's how the case got dismissed.
Okay, so I
Okay.
go down there and file an order, correct?
Yeah, and I would call them first to make sure, if you can submit it by email, you can send it to them. You may, yeah, what's that?
My file.
The pro per?
Remember that rule change?
Oh. Like, why don't you call them? They had a rule change since that was in July, wasn't it?
It was either June or July.
Yeah. Call them and find out how they want it submitted, because I don't remember the date that the rule changed indicating that pro pers were supposed to file electronically. And they're going to help you do that. You may want to call them to figure out, for them to tell you how they need the order filed. Because this comes out of a June 4th order, which I think is right around the time they changed the rule.
Okay, then that would be
Okay.
483-4426.
Yes.
Okay,
Yeah, that's the same file, 250222330.
The phone number is still this one.
Oh, yeah, yes, that's the phone number for civil. And I'm gonna place that we had the hearing and I granted, because they'll probably look at my notes. I granted the motion to set aside. And
okay,
then they may need a motion to set aside and then a motion to enact the order that came out of the hearing. Because that's essentially what you're requesting is we continue everything the same. And if I set aside the order of dismissal, then we will still need the order indicating what happened previously.
okay.
All right.
I
All
do-
right. So go ahead and call them and find out the way. I will indicate that I've granted the motion to set aside verbally, and then I will await however they figure out how you're supposed to e-file it, or whether you come in person. I'm uncertain because the rule changed. I would do it so they're expecting it.
Okay,
Right. All right, Mr. Lutz, you're all set. I've verbally set aside, granted your motion to set aside, and then I'll await the order to sign. My verbal indication doesn't mean anything. It's when I signed it that it's actually set aside. All right, sir?
okay. Thank you very
All
much.
right. All right, you're all set, Mr. Lutz. Thank you.
Thank you. Bye.
So his verbal doesn't really count until we
Well,
take
is there, I don't think we'll have a sequestration issue because it's being called in rebuttal. Yeah,
Correct, Your Honor.
so, yeah. So Mr. Barry, we're gonna leave you on Zoom. As long as you stay muted, you should be fine, all right, sir? We'll trust.
Yes, thank you, sir.
All right, thank you. All right, so the city rests, and Mr. Wobu, do you have any proofs today?
Yeah, Your Honor, I want to request, just like the email I sent to Tom Berry before, if they could give us some time where we're putting some effort to rectify the tax.
Sorry,
I said that we are doing a lot of efforts to see that those houses are on tax.
yeah, we're way past the investigation. We're in a hearing, and we were here for an entire afternoon, I think, for the city putting on proofs. Do you have any proofs today? Do you have any witnesses? Did you want to testify? You'd be subject to cross-examination, so you should understand that. Did you want to put on any proofs today? I'm not granting an adjournment since we're already in the middle of hearings.
So what is the question?
The question is, do you have any proofs today? Did you want to testify? Or do you have any witnesses who want to testify today? Okay. Did you want to testify today?
Yeah.
What's that?
Yeah, to testify.
Yes. You wanted to make a statement?
Yes.
Oh, all right. So what I'm going to do is I'm going to swear you in, and then I'm going to have you can go ahead and tell me your side of the equation. You can tell me your side of the testimony. I will allow Mr. Staples cross-examination, so you might have to get the witness chair. But I think it works better if your testimony is from right where you're seated right now. Okay. All right. I'm going to raise your right hand. You need to spell your first name and your last name for the record.
My first name is Christian Wobu.
Okay, and spell them both, please.
Wobu, N as Niger, W as water, O as orange, B as boy, U as umbrella.
All right, and then your first name. Spell your first name.
My first name is Christian, C as in church, H as hand, R as Richard, I as India, S as state, T as states, I as India, A as apple, N as Niger.
All right, Mr. Wilbur, do you promise do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
All right, you can have a seat. And why don't you tell me in your own words anything you want to say in answer to some of the proofs that have already been made, and we'll treat this as testimony, and then I'll probably put them on the scan for cross.
Okay. Yeah.
And you can have a seat, sir.
Your Honor, the two areas I want to speak on is regarding the Lahoma and
Okay.
Ohio.
So Lahoma and Ohio. So I'll go to the actual exhibits, and Lahoma. Okay, so those are the first two exhibits. Exhibit 1 is Lahoma, and then exhibit 2 is Ohio. So go ahead and tell me about Lahoma, sir.
Okay. Lahoma, initially I called on the month of, I believe in January, to arrange for the scheduling for inspection, which I arranged, and it was scheduled on 12th of February at 2:15 p.m. But on that day, there were few things there. I noticed that I couldn't be able to make it, and there were few things that we need to take care of. So I called to see if we can reschedule for the inspection. So the secretary that picked the call later contacted the code compliance office that's supposed to come in for that. So I spoke to him. Still, if they still want to do the inspection, then I can still come in.
The inspection was on February 20th?
It was initially scheduled for February 12th February.
And then it actually took place on February 20th.
Yeah, later I didn't know that one was That one, I didn't know. That one was search warrant that came in. But I wasn't aware of that when that one came in. But it was originally scheduled for February 12th. But I couldn't make it. But I called the code compliance office. So, of the opinion. So I think based on my discussion that we have ready, we shall get back to it so that we can schedule. Then it was on, I think on 19th. On 19th, I think I called on 19th to see if I can reschedule. So, but I couldn't get hold of the code compliance office. I couldn't get hold of him. Then on 28th, I called back to find out to see if we can reschedule it. I believe on 20th or 24th. Okay, I think it was on 24th when they picked the call that he told me that it was there was a search warrant in the place, because I wanted to see if it can be rescheduled again. But
So how many times did you request for it to be rescheduled? Just so for my records.
Okay. Before that warrant, I think one time I requested for rescheduling. So tell me when I think based on what I understood from you, when we are ready, we can call. But I didn't hear about that. You call back.
So when was the inspection done?
The inspection supposed to be on February. That was February 12th. February 12th was scheduled. But on that 12th, as I mentioned, that I called to see if it can be
Because
rescheduled.
the actual inspection, the ticket was written on March 24th.
Yeah, but that was
That was the actual ticket, the code compliance ticket.
Okay, yeah, but that was when they got what we call it, the search warrant to come in, which I wasn't aware. But it was the day that I called the shade. That was the inspector that's supposed to be for that one. He told me that there was a search warrant that I should call step for step that is I think it's step. Let me see that I should call, and I called several times and I left messages. So, but eventually, when we called after the search warrant, I think we requested for the inspection that came in.
So when was the inspection date on that at Lahoma done?
That was on March last year, but I requested before the search warrant requested for that one. That's the one for regarding the home. And there was also in what was mentioned in the statement that people were living there. There are no people are not living there. All of a sudden, people break in. So that we didn't allow or rent anything for that type of people. That's the one for that of
Okay. And then in regards to Ohio.
Then in regard to Ohio, we were working on the Ohio. There was a statement in the area that I rented the place for somebody. I never rented the house for someone. So
what date was that inspection?
The inspection for that one, I think the last inspection they had for Lahoma was 2 days ago. But there was inspection there.
It was in March. It was inspected in March. In March 12th, it was inspected.
So on that area for
so that was 4 months ago, it was inspected.
Yeah.
And the ticket was written March 24th.
Oh. Yes, that's what.
What did you want to tell me about the Ohio address?
Okay, the Ohio verse, the area they mentioned that I rented the place. Officially, I didn't rent the place, and I'm not collecting any money for any of that. I never collect that. I'm trying to ensure that the place is moving in before somebody moved in. But they moved in their things over there, and I took step when I noticed. I sent them 30 days notice, which I started the process. But you know, I agree that they cannot just stay there. We agree that no person should be in the house after 5 p.m., which I agreed and signed. And I dismissed the procedure because I tried to get him out officially, out of the place. So he signed. So that's what I want to mention in the area.
All right. And you requested today that it be adjourned because you continue working on the houses.
Yeah, we're working on that, yes. They had
All right.
inspection last on the area.
All right. Anything else you want to say to the court concerning any one of these, the 9 complaint tickets? You said some on Lahoma, which is Exhibit 1, and on Ohio, which is Exhibit 2, and then we have 7 more exhibits.
Yeah, Your Honor, what I want to ask is that if they could give me some time, because we're working to.
We've already started this hearing. We started a few months, I think, when did we start this? I think we started this hearing in June.
Yeah.
So that was, so we're from March, we're April, May, June, we started the hearing, and we're in July, that's still 4 months.
Okay. No, what I'm asking, the time I'm asking is in the taking care, because we are working already on those properties. We're already working on, and like that of Ohio, we scheduled the inspection was on Friday, but there are a few things that need to touch up, but almost 90% of the things. And the same thing also for that of 218 Lahoma. It doesn't mean that we sit down, we're still doing work on those.
What specifically you have done on the Lahoma address or the Ohio address since we had the last hearing?
Okay, but since we have I believe one of the things we did was also the inspection for the water heater. We did also the back porch, the chimney area that was done. We did also painting and what other than the bathroom. Most of those things were almost 90% of things were.
And those were, the ticket was written in March and you've done it in the last month.
Yeah, last month, yeah. No, we've been doing that even before, after the ticket.
Right. Anything else you want to tell me in regards to in regards to the 9 exhibits, or anything else you want to tell me?
Not for now.
Okay. Mr. Staples, did you want the opportunity to cross-examine?
I would, Your Honor.
All right. So, Mr. Wilbur, I'm going to stand up here because it'll work better.
Okay.
Might work better for recording purposes too. We'll make sure the fan is turned off.
Mr. Nwobu, if you could leave your notes, none of those have been entered into evidence.
Right, you're still under oath, and Mr. Staples, you can cross-examine.
Mr. Nwobu, you can have a
You
seat.
can have a seat, sir.
Mr. Nwobu, you are a licensed residential builder, is that correct?
Yes.
And you are registered, that license is done to the state of Michigan, correct?
Yes.
And to obtain that license, you have to take an exam, is that correct, originally?
Yes.
And to maintain that license, you have to have had originally 60 hours of education, and then there's a continuing education requirement that you have to meet every 3 years, is that correct?
Yes.
So it would be correct to say that you are familiar with the building codes of the state of Michigan and the city of Lansing?
Yes.
And you owned, let's take, for example, the 218 Lahoma, you've owned that property since 2016, is that correct?
Yes.
So it's fair to say that you're not new to this business. Is that a yes?
Yes, but we kept on learning.
Sure, but you've been a licensed builder since 2012? And you've owned at least some of these properties for almost 10 years, if not longer. And do you happen to recall when the last time you had a valid rental certificate on the Lahoma property was?
I think I can't be sure, but I believe the 2020, 2025.
So it's been some time since you've had a valid rental license on that property. And do you happen to remember when the last time you had a valid rental license on the Ohio property was?
Ohio, I think Ohio, I believe, I can't remember when it is. It's, I believe either 2022.
Say that again, sir, what year?
Maybe 2022, I can't remember.
20?
exactly when it expired.
So that's,
I'm not quite sure.
would you dispute that it was in 2022 was the last time you had a valid rental license?
I can't be sure of that one, but that's my guess.
So it would be fair to say that in December of 2024, that property did not have a valid rental license? I'm going to show you a document that's been marked as People's Proposed Exhibit 9, Mr. Nwobu. Is that your name there and there on that document?
Okay, yeah, that's my name.
And is that document, is there an address on that document?
Yeah, there's an address.
What is the address on that document?
The address is 1319 Ohio.
And do you recognize what that document appears to be?
Yes, I recognize.
What is it?
That's the rental, that is rental, that's rental documents.
So that's a lease?
That's a lease, but I wasn't the person that's there. I think there was something that manipulated because I never gave this lease.
But it has your name on it
My name is.
for a property you own. Your Honor, I would move to admit People's Exhibit 9.
Right, motion to admit People's Exhibit 9, which is a lease that you've signed. Is that your signature, sir?
This thing wasn't mine. This wasn't me that filled in this thing.
But is that your signature?
This is not my signature, but the upper one is my signature. But this one, this name.
But don't show me, don't show me the exhibit. So just answer the question, did you sign that?
Your Honor, I didn't sign this. I didn't sign this thing.
So the exhibit's under dispute.
Yes.
With that understanding, I'm gonna move for the admission of People's Exhibit 9. The witness indicates that although he says he didn't sign that document with that tenant, I'm gonna admit it into the evidence so that I can review the document. And then with the understanding that this witness disputes the document.
Fair enough, Your Honor. I will say for the court's records, Mr. Nwobu's name is in 2 places on that document, along with the tenant's name, who I believe Mr. Berry testified under oath last time that the property was occupied when he did the inspection. This is a copy of the lease that was given to Mr. Berry when he did that inspection, as he testified previously, Your Honor.
All right, with that understanding, I'm gonna admit People's Exhibit 9. Although the witness disputes it, it does confirm what the first witness indicated on direct examination. And you may proceed, Mr. Staples.
Mr. Nwobu, do you still maintain that there was not an individual living at 1319 Ohio Avenue on the date of the search warrant, which was for this property, February 19th of 2025?
I'm not disputing on that, but I've already issued them the letter which they signed. They shouldn't be there after 5 p.m. And I have a copy of that they signed.
But they were paying you rent to live there.
Your Honor, I've not received any cent from any of these people because the place is not rented. Because it's red tag. I never received any cent.
So I'm going to show you, this is a copy of what the court has accepted as the People's Exhibit. This number here, $1,100 a month payable on the 15th. You never received a cent of that?
I never received this amount. I never received any of this. I've received a cent.
But you don't dispute that people were living there and you were allowing them to live there as long as they weren't there after 5 p.m.
I told them they should, it's just only for work. Only work. Work out.
So they were hired contractors?
No.
So what was your arrangement with them?
The arrangement, the mark was doing some work. Arrangement when he contacted me that he wanted the place. I told him it's red tagged. That I have to finish the work over there before the renter so that they can sign the lease, they can move in. So we requested that he can help to ensure that its red tag were removed as soon as possible before they can move in. But I noticed eventually they move into the place. Then I sent them 30 days notice. I have it also here in the paper. Then I started the eviction on that. On the day of the hearing, then he pleaded now that if we can sign to dismiss it, that the person should be there after 5 p.m., which is signed, and I dismissed the case.
So you have then consented to them continuing to be there between the hours of 9 and 5 p.m. pursuant to a lease agreement they have with you.
Pursuing the lease agreement, I didn't have lease agreement with them.
You just said to the court that you have an agreement for them to be there, but they're not a contractor.
Okay, no, I told them that they shouldn't be there after 5 p.m. because Mark is helping in doing the work over there.
And he's
The
living
person
there.
should be
He's not a contractor.
It's not a contractor, but he do handyman services.
You're a licensed residential builder. Are you aware of the city of Lansing's requirements for work?
Yeah, what I understand per work, if the things that needed the permit, building permit, they ought not to do those things. It has to be under supervision and work of a licensed contractor.
But you have this guy, this Mark is just over there doing work.
The work he does is just that the few things that he does is just that few of the maintenance work. Not
Mr. Nwobu, do you debate or do you agree that all of these 9 properties are red tagged, or 8 properties, I'm sorry, are red tagged?
yeah.
So you admit that all 8 of these properties are red tagged?
Yes.
And that all 8 of these properties were red tagged on the date these tickets were written, which would be March 24th of 2025?
Yes, I know that.
So they were all of these properties had valid red tags on March 24th of 2025.
Yes.
No further questions, Your Honor.
All right, Mr. Wobu, is there anything you'd like to say in response to some of the questions that have been asked of you?
No.
All right, all right. May this witness be excused. Oh, Mr. Wobu, you can have a seat. Mr. Wobu, any further proofs today on your behalf? You can have a seat, sir. Any further proofs in your defense? Do you have any witnesses or anything else you'd like to say in your defense?
Okay, nothing.
Okay, all right. Rebuttal, Mr. Staples. Exhibit 9 is moved for the admission along with the 1 through 8. Mr. Staples, do you have any rebuttal in this matter?
Just briefly, Your Honor, with Mr. Berry, a couple questions to clarify some things Mr. Nwobu brought up.
All right. So let's go ahead and we'll re-swear in Mr. Berry. Mr. Berry, okay. So Mr. Berry, do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? All right. And you can restate your first name and your last name for the record, so we have it. And you're presenting via Zoom today.
Yes, my name is Tom Berry.
All right. And can you spell them both, please?
Oh, yeah, Tom, B as in boy, ARRY.
All right, Mr. Staples, you may proceed.
Mr. Berry, Mr. Nwobu discussed or claimed to the court that there may have been some inspection between February and the present for Lahoma. Was there any inspection between those dates?
Yes, sir.
And what did that inspection reveal?
That the items were not completely done. Most of it has been done, but there were still a few items on the exterior that were not completed.
I'm sorry, and to confirm, Mr. Berry, we're talking about 218 Lahoma and not 1319 Ohio?
Yes, that is correct.
Okay, and then what about 1319 Ohio?
I have not had any contact with him about that. One of my other code officers had tried to schedule an inspection for that one, which Mr. Nwobu did not appear.
No further questions for this witness,
All
Your
right.
Honor.
Do you have any questions for this witness, Mr. Wobu?
Yeah, the one he mentioned, I think,
So you should ask him that question.
the one you mentioned that I didn't appear on the inspection for hire.
Mhm.
But I have people that presented because there was something that I went to pick up. Because I have people that were present that was helping me doing work over there. that
Uh,
day. So
I'm
he-
sorry,
he-
I can't say that one more time. I can't understand you.
I said that I have people that are helping me working on that day. I ran to pick up a few material from Home Depot. So by the time I came in, because he warned me that if any single things is missed on the list, he will stop the inspection. So we have some area that were not painted. So when he stepped in, he said that he will not continue with that. Well, we shall finish it and reschedule.
What was his name?
That was Matthew Simon. Matthew Simon.
Uh,
Yeah.
That was Matthew Simon, yes.
Yes, that was Matt Simon, and he did say that it was not ready for an inspection. It was not completed.
Yeah, that was painting area because he said that he can't do anything if we miss any single thing, but we've done a lot of work on that.
All right. And do you have anything to confirm that with receipt or evidence to that effect?
Concerning that one, I have the what is it? I have in here Abad, sorry.
Oh, okay, sure. Yeah.
Abad was there when the inspector came in.
I don't understand what
I
you're
said
saying.
that Abad here, he was there when the inspector came on that Friday.
Did you want to call him as a witness?
Yeah, if you can, just to be a witness. You wanted a witness, if someone to confirm.
Yeah, we had a piece of evidence or something to confirm what you're indicating. Do you have any witnesses? And you indicated you might. And so that's somebody you might want to have testify.
Yes, Abba can testify that Matthew came.
You can't tell me. You have to call him as a witness.
Okay.
Your Honor, I think if I may, I don't think we dispute that there was an inspection done last Friday.
Right.
But Mr. Nwobu, do you agree that you did not pass that inspection?
Yeah, I didn't pass it because there are 2 things.
All right. All right. All right. Any further questions for Mr. Berry? Mr. Wobu?
Okay.
All right. Any further questions, Mr. Staples?
No, Your Honor.
All right. May this witness be excused? May Mr. Berry be excused from the city?
Yes, Your Honor.
Mr. Welby, can Mr. Berry be excused? Can he get off Zoom?
Yes.
All right. All right, Mr. Berry, you're all set. Thank you for your appearance today.
All right, thank you.
All right. Any further proofs today, Mr. Staples?
No, Your Honor.
All right. Does the city rest completely after the rebuttal?
Yes, Your Honor.
All right. Summation from the city, Mr. Staples.
Your Honor, the city has presented this court with several hundred pages of evidence relating the condition of these 8 properties. I will not go through those again, as it took us nearly 3 hours to do so last time, only to note that the violations contained in many of the violations here are legion. Dozens of violations on average per property. We're probably talking hundreds, if not several hundred individual discrete violations overall across all 8 properties. As was established in my cross-examination of Mr. Nwobu is not merely a property owner, Your Honor, but he is a licensed Michigan residential builder. He is well aware of the state and city housing codes. Furthermore, he has been a property owner in the city in excess of 10 years. Multiple properties. We have 8 here in front of you. I can tell you this is a small sliver of the properties Mr. Nwobu owns, many of which are either red tagged as the ones in front of you are, or pink tagged, which means they are not licensed for rental. Your Honor, I don't think it is bombastic at all to say that the conditions depicted in some of these photos of properties based on evidence in front of you and based on the photos themselves that appear to be lived in are heinous. These are significant life and safety issues. The city has also provided evidence to this court, both through testimony and through physical evidence, that Mr. Nwobu is knowingly renting these properties to people, that he, as by his own statements, is well aware that these are properties that are red tagged and unsafe for human occupation and rents them anyway. Your Honor, we do not bring these cases lightly. We ask that this court enter a fine against Mr. Nwobu of $500 per property and an additional $500 related to the 1319 Ohio property that we have been able to provide credible evidence that Mr. Nwobu leased, knowing well that he did not have a certificate to do so and while it was red tagged.
Thank you. Mr. Nwobu, is there anything you'd like to say to the court concerning summation of all the evidence the court's heard?
Your Honor, what I want to say in the area comment, they mentioned that I intentionally renting red tag house. I didn't rent red tag house. I do everything, even for the, if Your Honor, if you can also see, I try to see a way to help with the people, to work with people. If you see also cases, I try to ensure to help with the city. I know that the city to contribute to the development and help with the city things. So I'm not intentionally or I try to rent a red tag house. Some of those areas that was red tag, it was that they're sitting empty since it was red tag, but we are working toward that. And if you see a lot of other things we've done previously, at least from the month of February to June, we untagged more than about four houses. So we are working and taking care of all these things. And if we're given some time, we can be, I sent also email I sent to them, but I can be also sending monthly report on the how far we are going. We are working very fast to get this thing out of the way.
Is there anything you'd like to say else you'd say to the court? This is your chance for closing argument concerning the evidence that's been provided. Any response, Mr. Staples?
Your Honor, the city is asking for a $500 fine for property today, in addition to the $500 for Ohio, as I stated. We would ask that this be reset for compliance, and Mr. Nwobu can demonstrate, if he can, compliance at that time. If not, we would be asking for additional fines at that date that Your Honor might set. Frankly, Your Honor, the fact that these are properties that have been perhaps sitting vacant for a number of years and being left to rot to the elements is, in the city's opinion, no defense, but should be another offense in and of itself. The city is in dire need of housing, of good, safe housing, and to let these properties sit and rot for a number of years is unconscionable, Your Honor. Certainly not to the level of the ones that were lived in. That's a separate and a greater issue. But it is in and of itself a serious violation. And these, again, Your Honor, you've seen the pictures. We went through them in painstaking detail. These are not minor issues. These are not missing light switches and a knob falling off here and there. These are significant, serious issues. And there is substantial evidence from the photographs themselves, if not also from the lease and the testimony of Mr. Berry, that people were living in these houses and people were being put at risk by Mr. Nwobu. And with that, the city rests, Your Honor.
All right, thank you. I've had the opportunity to see Mr. Berry as a witness testify at length concerning every ticket that was written. And then Mr. Nwobu's, that happened in June. And then we set it for the July 28th date today for any other additional evidence to come forward. And Mr. Nwobu has come with his own testimony. He had a witness here last time. I don't know where that witness is today. But the standard, my understanding of the standard for compliance is a preponderance.
That's correct.
And I find that not only by a preponderance standard, but greater than preponderance, it could be clear and convincing. We could go to reasonable doubt that that the city has proven their case, okay? So I'm gonna make a finding on each ticket as I see the tickets. But this is as to ticket 0629, number 0629. That was a ticket for the written ticket on March 24th, 2025. And then I believe there are pretty close to 50 exhibits under the ticket concerning photographs that the Lahoma 218 Lahoma, when the ticket written, is out of compliance. And that goes without saying. Maybe something's been done afterward, maybe in April, in May, in June, maybe between the first hearing, the second hearing, something's been done, but it's way past the March 25th date as far as what's been done on this. So I'm going to find a $500 fine concerning non-compliance when the ticket was written on ticket 0629, and we're going to set that for a control date. So Mr. Wobo, what we're doing is we're setting that, we're adjourning that. So you can see, and this is to work with the city, you've got to indicate exactly what you've done in order to be in compliance. If you're still out of compliance in the next 30 days, you're just going to see another fine, okay? Since March, this has been going on, and this has been going on way before March, years before March. And it's this court's responsibility to start cleaning this up, okay? So it's a $500 fine on that 0629, and we'll set the control date for, and I would say probably 4 to 6 weeks out,
That would be fine, Your Honor.
maybe. It'd be about an hour. We're gonna set them all at once, so
Can we do September 8th at 2?
we set for September 8th at 2 o'clock.
Your Honor, I have orders prepared on each of these.
Right.
Do you want me to give them to you all at once?
Yeah, you can give them to me all
They
at
should
once.
be
and
in
then-
order.
All right,
And there's a blank for the date on the second
All right.
page.
so this is on 621. I need 629. That
Yeah,
should be this one, yeah,
This should be for 218 Lahoma, which is ticket 629.
right.
It is case number, it is the one that doesn't start with a 30 something.
0629, is that's the ticket number I have
Yeah.
for
It is,
exhibit, is that Lahoma?
yeah, and that's, yes, that is Lahoma, and
Okay.
that's docket number, just a second, Your Honor.
6291.
Yeah, 6291.
All right, so we will set this for on or about September 8th at 2 o'clock. I'll go ahead and write it in. And that one's signed for $500. That'll be a fine. And then compliance is to be made for first September 8th. We're going to set a control date. We'll be here, and you can tell the city what you've done, and we can go from there. On the Ohio address of 1319 Ohio, which is 6301. 630. Okay. I find the city has met their burden of proof by a preponderance of the evidence, and I will set a $500 fine on 630, the ticket, and that is file 6301 or 25006301. There'll be a $500 fine, and then as an S2 Exhibit 9, it'll be an additional $500 fine at the city's request. And that would be, so it'd be $1,000. And then that will be reviewed as a control date of September 8th at 2 o'clock. So it's $500 concerning the first fine, an additional fine for allowing somebody to live in a house that's been pink tagged. I can't say it better than that. And that will be set for September 8th at 2 o'clock. Then we have. So 630. Then we have the 631. And that is the Richmond address, 4104. I believe that the plaintiff has proved their case.
We completed that one.
Okay, but not in March, you didn't. You completed it now, but you didn't do so in March. And we're only worried about the ticket, when the ticket was written, and the ticket was written on March 24th. That's the compliance. So share any updates you've had for compliance with the city, but I'm finding you not in compliance with the code because on March you were far from compliance with the code. As a matter of fact, I think we saw on 631 24, at least 24 exhibits on that ticket alone. Okay. So, because we've got up to number 24. So I'm going to have a $500 non-compliance penalty for that. So that'll be an additional, so that'll be in 631, $500. And we'll set that for September 8th at 2 o'clock. And I'm going to sign the city, the order indicating that $500 is fine. And we'll set that for September 8th for a control date. And I will sign the order accordingly. And then we have, and that is for the Richmond address. And then we have 632. And that is for the Hughes address. Make sure it's 632. Yep. I'm going to find for non-compliance on March 24th, 2025, when the ticket was written, a non-compliance fine of $500. Then we'll set that for a control date for 632, September 8th. And I will sign it for today's date of July 28th, 2025. That'll be, I'll give you a running total of all the fines to be paid, but that is on the 5933 Hughes address. And then we're on 633, which is the Magnolia address, 720 South Magnolia. Find that the city has proven their case for non-compliance by a request of $500. And the case will be set for September 8th. At 1:30. 7:28. And so that'll be an additional fine of $500 on 6331.
You said that on 130 or 2?
What's that? That's on 6331, and then we'll be on 633. That is for 720 South Magnolia.
Okay, you said 130?
I think there was, it's
Yeah.
2 p.m.,
2
correct,
p.m.,
Your Honor?
Correct.
Okay, sir.
Yeah. So that'll be set. That's the same date for all these.
Okay, okay.
And then we have 634, which is docket 25006341. And that is the 916 Cleveland address. I find that the city has met their burden of proof by preponderance of the evidence, and that's an additional $500. And that we'll set that for control date on September 8th at 1:30. sign that order. That is on 25006341. That is the Cleveland address. Then we have 635, which is the 910 Cleveland address. I find the city has proven, based on their witness and the exhibits by preponderance of the evidence, that the property and Mr. Wobu, it was out of compliance on that March 24th date. Once again, work would have been done since then, and maybe since the last hearing, but still out of compliance. And we'll fine it for another $500. And set that for September 8th, 2025 at 1:30 as a control date for compliance. We're going to go to 2 now.
It was always at 2.
Oh. What was the 1:30? We'll be here from 1:30 to 2. So it really doesn't matter. 910 Cleveland. And then on 636, so that I have 25006361. That is the last address, and that is the 1115 Camp Street address. We'll set it for $500. The city has proven their case by preponderance of the evidence, and we find non-compliance in that matter for $500, and that'll be set for September 8th at 2 o'clock. And all these will be in that 1:30, 2 o'clock range. I will sign accordingly. All right, so let me give you so the running total that must be paid to the city of Lansing for non-compliance would be the $500 for Lahoma, the $1,000 for Ohio. The Richmond address is another 500, so that's 2,000. Hughes address is 500, that's 2,500. Magnolia address is another 500, that's 3,000. 916 Cleveland is 500, that's 3,500. 910 Cleveland is 500, that's 4,000. And 115 Camp is 500, that's 4,500. Is that correct?
That's accurate, Your Honor.
So all that must be paid by that September 8th date for compliance purposes ordered by the court for lack of non-compliance. And then we can see what's been done on the addresses since this date. That you'll have till September 8th to see if additional fines are requested for the city. But I find that by a myriad evidence, much higher than preponderance, through that afternoon of exhibits, which must be per ticket, we're in the 20 to 25. Some of those we had 40 to 45 exhibits, photographs that Mr. Berry testified to. That's where the $4,500 comes from. So that's $4,500 to the city of Lansing. And we will reconvene a control date to see if any measures have been taken for compliance on September 8th at 2 o'clock. And you'll probably get notice for the 2 o'clock number on all. I think there's 9 files. I think there's 9 exhibits altogether. There's 8 tickets and 9 exhibits. Anything else for the record in any one of these dockets? So that's docket 25006301, 6311, 6321, 6331, 6341, 6351, 6361, or 6291, Mr. Staples.
No, Your Honor, if we could just perhaps have copies, I can hang around a minute. I know you guys have other things to do.
Yeah. Yeah, you have the orders. I don't know, I can give you copies of the signed copy of the orders. Mr. Wobe, do you have any questions of me?
No, Your Honor, just one of the things I want to request also, we are going to work very fast on these properties. So one of the things I want to plead also, so they can work with us. Because sometimes some of these things that require inspection, like electrical, there are things that sometimes a lot of these are scheduled off so far that sometimes like my hope, the things now we're supposed to have untapped the place for almost the electrician, we're waiting for them. So if they can consider
Well, I only have the 8 properties in front of me, okay? And so you know that there's a date, September, I'll still give you the date, right? September 8th at 2 o'clock. We know that from this hearing to then, whatever work's done should be gone to the city, because that's going to reduce your fine on some level, I would think. Because at some point in time, if nothing's done on these premises, the city's gonna come in and ask for an abatement, which means that they're gonna say, okay, somebody's gonna fix this, and if you won't fix it, we'll pay somebody to fix it, and then you'll get the bill. That's where I'm afraid we're heading, because we have so many properties. But we'll look at the control date, September 8th. Mr. Wobu, this has been going on for quite some time. So it's time to fix this. It's time to fix this. That's why the fines were today. I would expect additional fines if compliance isn't met. So you should keep in contact with the city to make sure, because I only have these 8 tickets in front of me. I'm expecting that there's more property out there. All right, sir? All right, so we'll see you on September 8th at 1:30. That's all for the record on all of these 8 cases. Thank you, Mr. Staples.
All that
Yeah, I'm gonna,
stuff, just so we can.
Here are the
so they can
exhibits.
put it in.
The ROAs, they won't get till tomorrow.
Okay.
Yeah. So we'll deal with the ROAs. But do you want the exhibits back? Yeah.
This is 9.
Is this what you need copies of?
Yes, I've got exhibit 9 also, yes. Yeah, the exhibit list,
It's gonna cost you.
and then I'll give you the ROAs.
I just want to make sure we get a number.
No, they'll get it when they get it.
They can put the money where it goes, so if you get the price to pay it, you know.
All right.
Try to keep them in order.
Is Mr. Dowrick here?
Okay.
Is Mr. Kluger, are you from South Washington?
Yeah, Sean Mock.
Is Mr. Mock?
Yep.
You're here for the Klug Law Firm. Is Mr. Anderson here?
Yes.
All right. On that case. All right, so we're on the record in docket 25-03512. That is South Washington Park versus, and you're correct by pronunciation, Davin Anderson or David Anderson?
Davin.
Davin. All right. Appearances for the record, Mr. Bach.
Thank you, Your Honor. Attorney Sean Mock, P78785 for the plaintiff.
And sir, you are Davin Anderson, is that correct? All right. This is the time set for a formal hearing in the matter. It was set previously on July 16th. Mr. Mock, how we proceed?
Thank you, Your Honor. I've had an opportunity to speak with the defendant and discuss this matter, and we have agreed to the terms of a consent order for conditional dismissal. Your Honor, this is a termination of tenancy case. So we have agreed in a conditional dismissal that the defendant will vacate and turn in keys by August 7th, 2025. And box 4B is checked indicating that the plaintiff may proceed to obtain judgment and an immediate writ without further notice if the defendant fails to vacate by that date. I have indicated that I have explained MCR 4.201J to the defendant, and I do have a conditional dismissal bearing the signature of both parties, if I may approach.
You may approach. Thank you, Mr. Mock. All right, so I'm in possession of the consent order for conditional dismissal on 25-03512. The box 3 is checked The defendant will vacate and turn in keys by August 7th. 4B is checked. This action may proceed without notice to the defendant or further process if the conditions are not met in this case. And 7, a partial payment will not prevent the issuance of an order. You've signed this, Mr. Anderson, is that correct?
Yes.
All right. You understand you have 3 days from today's date to indicate that something we did here was vague or ambiguous or you didn't understand it because you're not represented by counsel. Do you understand that, sir?
Yes.
All right. With that understanding, I will sign the order. And we will be responsible for signing and scanning it to the e-file system and provide a copy to each of the litigants for the records. Anything else for the record in 25-03512, Mr. Mock?
No, Your Honor, thank you.
Mr. Anderson, do you have any questions of me?
No.
All right, you should be all set. Thank you for your appearance today. I will call City View in 1 minute.
No problem, thank you.
You're from the Larson Law Firm?
I appreciate the promotion, but no. Mallory left Scott and Keelan.
All right, I've got Larson as the law.
That's my
firm.
last name, Jessica Larson.
Okay, perfect. All right.
My bosses will be happy to hear that.
And is there a Taylor Brown or a Stephen Kaufman here?
They're both, I think, walking in right now.
Okay,
They just stepped out to the restroom.
all right. All right, so you can come up. Taylor Brown and Stephen Kaufman, you can come up. All right, so we're on the record at docket 25-02816. That is City View Apartments versus Taylor Brown and Stephen Kaufman. Will the parties please introduce themselves for the record? Ms. Larson. And
Good.
that's the previous name.
That's my current name.
That's your current name,
Yes,
okay.
yep. Jessica Larson on behalf of the property City View Apartments. And I do have a representative of the property with me.
All right, thank you. And who is Taylor Brown? You are Taylor Brown? All right. And you are Stephen Kaufman?
Yes, sir.
All right, thank you. All right, this is the time set for a formal hearing today. It was set for formal hearing on July 16th. Ms. Larson, how are we proceeding?
Well, I spoke with both defendants before we got on the record today, Your Honor. I think I probably could work out some sort of arrangement with Ms. Brown, but I understand Mr. Kaufman is not in agreement with the amounts owed. I guess I'm not really sure what his position is. He wants some sort of offset, I think, but it's not clear to me what he wants and how much and why.
Did you want to go forward with the hearing?
Yes, Your Honor.
All right. And you have one witness today. I'd assume that's the property manager?
Yes, and there was a change in property manager, so I have one here in person, and then if necessary, I do have one on standby on Zoom.
All right. And since this is an adversarial hearing, I'm going to give, can you, first of all, Mr. Kaufman, you're going to be cross-examining the second witness. Do you okay by Zoom or would you require it here? Because if you want him here, we'll probably have him here.
But if you're okay with Zoom, so am I.
I'm fine with it. I'm good as long as the person's here via Zoom.
Certainly.
And you can ask the questions. It doesn't always work out, but I always ask since we're having an adversarial hearing, I always ask the other side, if you're okay with Zoom, we can work through it.
Yes, sir.
Okay. All right.
Thank you, appreciate that.
All right. So Ms. Larson, I'll indicate that all parties appeared. and we're gonna have a formal hearing. So before you call your first witness, Ms. Larson, I'll have you do some opening statement. Just tell me the basics of why we're here.
Sure, thank you, Your Honor.
You can have a seat, and then I'll have the same from you, Mr. Staples.
One missed inside.
Oh, did it?
I just didn't want to interrupt you.
Sorry.
No, that doesn't surprise me.
It's not the original, right? Because
No.
the original's gonna need to be signed. Which one is that?
This
What number?
is one of the Cleveland addresses.
910.
All right,
Original.
right. So Ms. Larson, you may proceed with just some of the basics of why we're here.
Sure, thank you, Your Honor. The defense in this case moved in on March 1st, on or about March 1st of 2025. They received multiple concessions as part of their move-in package. Their monthly rent per the lease is $1,310, but there is a current lease concession that's happening of $335. So that results in net rent of $975 a month. Also pursuant to the terms of the lease, there are.
So that's what they're responsible for, the $975.
Yes, Your Honor. There are monthly fees, including a water service fee of $35, a cable and internet fee of $65, and then also as part of the electric fee that'll show on the ledger, there are a couple of charges where the tenants did not pay the electric that was charged to the company, and so there are 2 charges for electric fees that are also part of the utilities that are unpaid. In addition to that, Your Honor, the ledger will also show that the security deposit of $810 was never paid. It was agreed upon that the parties could move in without having to pay that security deposit in advance, but it was obviously still part of something that was owed as part of the terms of the lease.
All right.
In addition, Your Honor, there's been discussion about an additional move-in concession. There was 2 months of rent that was agreed upon as a move-in concession, which totaled the actual total, not just the $975, but the $1,310. So there was a credit of $2,620 that was also applied. That I think will be part of the proceedings here today. That is applied as part of the balance that was given as a credit at the beginning of the term of the lease.
And when was the lease signed?
It was signed, I know the move-in date was March 1st. Looks like February 28th of 2025.
Okay, so the allegation isn't that the money is not owned, it's the amount of money.
And so what I think you're going to hear from Your Honor, from the defendants is that there were 2 issues. There were some ants that were in the apartment that from my client's testimony, there will be remediation efforts and that they're not aware of any current ongoing ant problem. And that there was a leaky roof that my clients have been working to address. They've had several rounds of remediation efforts trying to figure out and from the best that they can ascertain, it's a leak in the sprinkler system. So those are really the issues that we have, Your Honor. And those are, I believe, where the defendants are disagreed on the amount of rent.
All right, thank you. I think I've got the general lay of the land here. Mr. Kaufman, is there anything you'd like to say in opening statement concerning disputing the amount owed?
Yes, Your Honor. In regards to what she just said, we talked in the conference room before coming in here, and we talked about that there's still a bug problem. And also the roof leak has just been fixed a couple weeks ago. It was first brought up to management 4 months ago. And there's still a hole in my roof, as well as they thought it was coming from the ceiling, and it wasn't. It was coming from the sprinkler system. So that begs the question, were the sprinklers active in a case of a fire as well?
All right, Ms. Larson, you can call your first witness. And then, we're going to hearing today, so you have to provide any evidence.
Yes, sir.
Okay, all right. All right, Ms. Larson, you may call your first witness.
And can I get the Zoom ID, Your Honor, so that I can have my other witness on standby?
Yes. What's our Zoom ID?
318 569 6632.
Some people have it by memory. I'm not one of those people.
Yeah. Is it okay? He's just going to text the other witness the Zoom ID so she
Sure.
can get logged in.
On the previous one or on this one? Okay, why is that?
Because if they're gonna testify, I can't always hear.
Oh, yeah, yeah,
It
yeah.
ends up like the muppets and there's no way to clear it. That's like time. That's fine. 6:60. There, we go. Okay. Thank you. Okay.
All right, Ms. Larson, you can call your first witness.
Aaron Neuer. Am I saying your last name? Noise, I'm sorry. Go ahead and have a seat right
All
there.
right, please, you can come forward and please state your first name and your last name and spell them both for the record.
Aaron Noyes, AARON NOYES.
Okay, please raise your right hand. Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
You may have a seat. The microphone goes right to the court recorder's ear, so it doesn't amplify your voice. So please project as best you can.
Yes.
When you're ready, Ms. Larson.
Okay. Aaron, how are you previously employed?
With Friedman Management Real Estate with, I was currently at the time with City View.
And in March of 2025, were you a manager at City View Apartments?
I had just exited and phased out right around that time.
Okay. Are you familiar with Taylor Brown and Stephen Kaufman?
Yes.
Were you the manager at the time that they signed their lease?
Yes.
What was your understanding of the monthly concession that was to be received?
So what we had communicated upon was that if they decided to agree to sign the lease, they get two different concessions. One is a one-time concession of so 2 months rent free. We always recommend that they take advantage of that however they want. They could break it into 12 installments, but we just drop it as a one-time right at the beginning of the lease. And then the other one is I think it's $355 off, and that was a monthly concession.
If I showed you a copy of the ledger, would that refresh your recollection on the monthly amount?
Yes.
It's just a copy of the ledger.
Yeah, so they received a $335 monthly concession off their rent that was recurring, and then received the 2 months base rent as a one-time concession.
So that's $335 was part of the concession.
Yes, and that was recurring for the remaining of the 12 installments of the lease.
And as part of the lease, do the tenants also get charged for water and cable and electric or cable and internet, excuse me?
Yes.
And those were regular monthly fees.
Yes, so they're flat rates, so those do not change.
Was it part of the agreement that the electric bill would be paid by City View Apartments?
No.
What would be the circumstances where an electric bill would get added to a tenant's ledger?
Once we've had to get a cost recovery request from the utility company. So if it's either turned off or shut off, then it goes automatically back into our original account, and then our accounting team receives it, the bill, and then pulls the bill exactly for that unit specifically and puts the bill only onto their ledger.
So this would be actual out-of-pocket cost incurred by the property.
Yes.
And what amount does the lease agreement state for late fees?
After the business day of the 5th, it's $250.
And other late fees and incurred on the ledger as well?
Yes.
And you understand there's a charge on here for legal fees as well?
Yes.
You understand that would not be that would be backed out of the ledger and included in court costs separately?
Yes.
Now it's indicated on here that the security deposit of $810 is owing. Can you explain to me what happened there?
Yes, so upon when they moved in, they decided to use their credit that was given for the 2 months free toward that remaining balance due at moving day.
Was that something that you discussed with the defendants in advance?
Yes, at move-in day we discussed it, but it's something we discussed. We send a move-in letter with a breakdown of the cost that's still due.
Was there ever an agreement that the tenants would not owe the security deposit?
No.
And you're not currently the property manager, is that correct?
Not anymore.
Okay. Were there any other concessions or anything in regards to the move-in of Ms. Brown and Mr. Kaufman?
None.
Okay. I don't have anything further for this witness.
All right. I may have questions. So was the lease signed on February 28th?
Yes.
Okay. And just to clarify, there were two concessions that were to be made. One is for the $2,620, and that was to be either lumps, we used lumped or spread across the time, and they chose the lump sum payment.
Yes.
And that represented the first 2 months.
Yes.
Okay. And then there was a $335 concession made per the lease agreement.
Yes.
On the month. Okay. The outstanding security deposit of $810, that never came out of the $2,620 concession. Is that correct?
Not until after they moved in, did not pay the security deposit. That concession was sitting there and it went toward the remaining balance due.
All right. So that did come out of the $2,620.
Yes.
And then they had a remaining balance of $2,620, and that would be the minus $810.
Yes.
So it'd be $1,810 left.
Yeah, of a credit.
Of a credit. Okay. All right. Mr. Kaufman and Ms. Taylor, do you have any questions concerning this witness? Mr. Kaufman.
The $800 move-in fee, were there multiple move-in fees or just the $810?
It would be the $800 would be your security deposit that was remaining due, and then any prorated cost of the flat rates.
Which would be how much and what for?
I'd have to review the ledger because it would be posted on the ledger at the
Okay,
beginning.
I'd like to be privy to that as
All
well.
right. So you can give him to refresh his memory. Just to answer the question.
Since they moved in on the first, it was not prorated, it was a full flat rate of 31 days for $35 for water. And then for 31 days, flat rate for internet was 65, so nothing but prorated. So moving costs would have specifically just been the security deposit, $810, $35 for water, and $65 for internet. And rent would have posted for $1,310. And then that credit was put in for $2,620, as well as the other credit of $335.
So as in the move-in day, are you saying we owed the $1,300 plus the $1,800 on move-in day?
So on moving day, you would have owed a total of 1 month's rent with the $810 of the security deposit and $35 water fee and the $65 cable fee.
Due upon move-in day?
Yes,
Okay, and so how were we able to move in if we didn't pay that?
because you used the 2 months free concession that we gave out to use to pay the remaining balance.
Okay, so how is that still owed if we use the concession to pay for it?
So, and
Only the remainder of the concession would be,
because there's nothing, the owed is just past due rent at this point.
Right, I'm trying to lay the foundation for how we got here.
right,
Yeah.
right.
I'm not saying those sums specifically are outstanding.
Right.
Yeah.
We were just laying the foundation for how we got to this, where we're working through the dispute.
Right. Right, and I don't want the defendants to come back and say, well, we're entitled to the $2,600 because it didn't get applied. We're showing what it got applied to.
Right. Any further questions?
Yeah.
Okay. Ms. Brown, do you have any questions? Okay. Is that a yes or no? Okay, thank you.
I do have a question. I do remember paying a $500 move-in fee.
Yes, which
Like
when
that.
So you'll have to speak up a little bit because we're having trouble picking up your voice.
I do remember paying a $500 move-in fee. So I just wonder if that ledger shows that.
yes, so you paid the application fee of 75 and the $500 holding fee on 2/27, which the holding fee of $500 goes toward your security deposit, which is 1 month's rent. So you did put that down, and the remaining due is due at move-in day, which was the credit that was used against the remaining due of $810.
So Mr. Coffin, did you have a question?
I do, Your Honor. So if you say we did pay the 500 on the move-in day?
Yes.
Okay, so how is it that we paid the $500 move-in fee, but didn't pay the $800 move-in fee, yet
So-
still owe it, and we're able to move in without paying the price that it costs to move in?
So upon move-in day, the remaining balance due on the security deposit is only $810. Your security deposit agreed upon on the front page of the lease was 1 month's rent base of $1,310, leaving you with a remaining balance of $810 upon move-in day.
Okay, and you're saying that there was nothing done to move around that $800 move-in fee? You're saying that we were just supposed to pay it?
Yes, which was agreed upon in the lease agreement. And it was sent in as a move-in letter and agreed upon verbally when we made the agreement for move-in day.
Okay, and that was between Mrs. Brown and myself, or both of us, 400
Both of you
each,
were
405 each?
Present.
But who did come out of financially? Who was supposed to
Joint,
pay?
you guys are responsible for each other on the lease agreement, so it's a joint
Okay.
responsible.
Okay,
It's a joint and several lease.
Yes,
And do both their name signatures appear on the lease?
yes.
Any further questions, Mr. Coffin?
just a comment if I may, Judge.
You're gonna have plenty of time for
Yes, sir.
comments.
Yes, sir.
May this witness be excused from the plaintiff?
Yes, sir.
All right. Besides the comments, and I'm gonna give you time to make a summation. Do you have any questions for this witness? Any additional questions?
No, sir.
All right. You're excused witness, all right?
Thank you.
And then I have Alyssa Cherry on. Is that
That's
the
her.
second witness?
Yes.
All right. All right. So Miss Cherry, you'll have to. I don't have to see you, but I have to see your hand raised at some point in time. So I'll have to see your hand raised, Miss Cherry. Do you have any video?
Yes, I will switch to a different device right now.
All right. You can keep that device because we can hear you perfectly. I just want to make sure your hand is raised so I can give you the oath to testify truthfully.
Absolutely. I will, I can do that from my phone. My camera on my laptop is not working at the moment.
Okay. Usually what I do under these circumstances is I would confirm that your hand is raised and then we can put it on the record and the record would reflect. Ms. Cherry, can you do that? Can you raise your right hand for me?
Yes.
All right. And we'll confirm on the record that the witness has indicated her right hand is raised. Is that correct?
Yes, that's correct.
All right. Can you please state and spell your first name and your last name?
Yes, Elisa Cherry. My first name is spelled Alisa. My last name is spelled Cherry.
All right. With your right hand raised, do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
All right. And we can hear pretty good right now. So there's always the fear that if somebody's on Zoom, you'll get a lot of inaudibles if anybody orders a transcript. That's the fear, okay? So Ms. Larson, you may proceed.
Ms. Cherry, can you hear me okay?
I can.
Okay. How are you employed?
I am employed by Friedman Real Estate. I'm the community manager at City View.
Thank you. And are you familiar with the books and records for Taylor Brown and Stephen Kaufman?
Yes, I am.
Are you familiar with the work orders that Mr. Kaufman and Ms. Brown have placed since they've moved in?
The only work orders on the account are ones that were entered by me. Mr. Kaufman and Ms. Brown have not entered any work orders.
And what do you mean by that? How would work orders normally get submitted?
Typically a resident would submit them through their resident portal. In this case, I reached out to both residents regarding the past due balance on their account, and they informed me that they had multiple issues happening in their unit. So I manually entered the work order at that time. so that we could get these things taken care of and document, when all of the repairs were made.
And did you enter these work orders the day that you were notified regarding them?
Yes, I did.
And what day was that?
The first one was on June 6th.
And what issues were reported?
Give me 1 second. I'm pulling up the work order. Sorry, I'm just switching screens here to pull up the work order.
That's June 6th of 2025.
That's
Correct.
2025, correct? Yes.
Yes, it is. Okay. They were having an issue with a sink stopper in their bathroom that was replaced. They were having an issue. Their dishwasher was not working. It was just unplugged under the sink. They cited that they had ants near their sliding glass door. We had a pest service come the following Monday. And they said the garbage disposal was also not working. In the work order, there are some detailed notes as well. The breaker was tripped for the garbage disposal. Dishwasher was unplugged. We had to order the sink stopper. We installed that as soon as it came in. And we had our pest company come and treat their unit on the 9th. And then on the 10th, they came for the major issue that they were having, which was a leak coming from the sprinkler head in their ceiling.
And you said that was June 10th that somebody came out to look at that?
That was the first time they came out, that someone came out, yes. And they made a repair on the roof.
And so did the tenants report that the leak had stopped?
They did not. The next time that I spoke with them, I asked about it and they told me that it was still leaking. So I had the same contractors come back out again. They made another repair on the roof. I didn't hear anything about it for a couple of weeks. The next time.
So what date was that?
I can tell you, this is all, it was all over text with Miss Brown. And those are all through
Okay,
our
what month
system.
were you aware, what month did you become aware that the initial repair was not satisfactorily done to the tenants, that it was still leaking?
Give me just one moment. I'm looking at the text messages right now. On July 3rd, Mr. Kaufman let me know that there was still a slow drip coming from the sprinkler head in the ceiling.
I'm sorry, Ms.
Contractors
Larson,
came.
I just didn't hear a date, so I wanted to clarify.
Sorry,
No, I
July
appreciate that, Your Honor. I was gonna. So between June 10th, when you had indicated that there were workers on the roof, that made repairs, and July 3rd, did you have any indication from either tenant that the roof or that the leak was still happening?
I did not.
Prior to, you said that this issue was first reported to you on June 6th. Prior to June 6th, did you have any, were you aware of any efforts by Ms. Brown or Mr. Kaufman to notify you regarding any of these issues?
No, I was not.
Did you ever receive any voicemails from Ms. Brown or Mr. Kaufman regarding any of these issues?
I did not.
Did Ms. Brown or Mr. Kaufman ever come down to the property office to speak with you in person?
No, they did not.
And is the property office, is it actually in the bottom level of the building, the apartment building itself?
Yes, it is.
Since June, you said it was the Monday following June 6th, when the pest service came out to address the ants. Have you been notified by either Mr. Kaufman or Ms. Brown that the pest issue remains ongoing?
No.
What is the current status of the repairs to the sprinkler system since July 3rd?
The repair is complete. Remediation is complete. They will be coming on the 29th and the 30th to complete the drywall and paint. And the residents were notified of that as well.
During any time in when repairs were undergoing for any of these issues that you've addressed, have Mr. Kaufman or Ms. Brown requested rescheduling for their own for their schedules?
Yes.
Did they give any indication as to what the reason was for the reschedule was?
There were various reasons. There was one date that they weren't feeling well. Mr. Kaufman will not allow us in the unit when he's not there, citing that he will not allow us in the unit alone with Taylor. That's pretty much it. Just that they're not feeling well or they didn't get enough sleep.
Have there been times that they've refused access to any of the workers on either scheduled or unscheduled dates?
Yes.
More than once?
There was just one time that they refused once a contractor was already on site.
Have Ms. Brown or Mr. Kaufman come to you to have any in-person conversations regarding any of these issues?
No, they have not.
And do you have a copy of the current ledger in front of you?
I do.
On that, can you tell me the total balance owed on the ledger?
$4,029.69.
And how many months of rent is that for?
This would be 4 months.
So the tenants moved in March 1st of 2025, correct?
Yes.
So March, April, May, June, July would be 5 months?
Correct. Yes, 5 total.
Okay. And to date, how many payments have been made by Ms. Brown and Mr. Kaufman?
Let me double check this. It looks like there was a payment made on April 5th for $540. And that is the only payment on the ledger since other than application fees and those initial move-in costs.
And that does include application of the $2,620 move-in concession?
Correct, it does include that.
So that would be 5 months of rent at $975, is that correct?
Yes, that's correct.
And 5 months of water service at $35?
Correct.
And 5 months of cable and internet service at $65?
Yes.
And there's also on June 2nd of 2025, there's an electric charge with dates from May 2nd, 2025 to May 17 of 2025.
That is correct.
$70.20.
Yes.
And what would be the reason that would have been applied to the tenant's ledger?
The resident had removed the utilities from their name with Board of Water and Light.
And so was that a charge that was incurred by the property?
Yes.
And same thing on July 3rd of 2025, there's an electric bill from 5/18/25 to 6/16 of 25 for $129.49. Is that correct?
Correct.
And then I'm showing 3 late fees of $250 each.
Yes.
And did you, on my ledger, there's $130 for legal fees. Did you remove that from the ledger?
We have not removed that from the ledger.
Okay, So that would need to come off of the total that you gave,
Yes.
and that would be accounted for in the court costs in a different place on my end. Are there any other charges or credits or anything on the lease ledger that we have not talked about?
Not to my knowledge, no.
I don't have anything further this time.
All right, Ms. Cherry, you should entertain some questions from first Mr. Coppin, then Ms. Taylor. Mr. Coppin, do you have any questions of Ms. Cherry?
Yes, Your Honor, I do. First one would be, what was the date that, in your words, I refused entry by a contractor to perform work? And who was that contractor?
It's been Premier Property Services. Give me just one moment to pull the work orders back up. That would have been, I apologize, give me one moment, I'm just going through the notes on the work order. I apologize, I misspoke. The only reschedule that I have is for 6/5, and we moved it to 6/6.
Right, so there was no denial of access.
There was, I could not tell you the date. I don't have it in my notes.
Right, any further questions, Mr. Coppin?
Yes, Your Honor. So would you say Premier Contracting was the company I denied entry?
Yes.
Okay, is that still the company that I supposedly denied entry?
Correct.
Okay, and what kind of work do they perform? Was it drywall or fixing the fire alarm?
They
Sprinkler
were
system?
there for, so they did the 2 initial repairs on the roof, as well as drywall and painting. They're the company that would do those as well.
And you're saying that was on 6/5 or 6/6?
I do not have the date in my notes. I'm unfortunately not able to give you an accurate date on that.
Okay, so drywall and painting, would that be the company that removed the drywall from my unit?
That was Boynton Fire Service.
Okay, so then what drywall or paint work did they do?
No one has done that yet. That is rescheduled for the 29th and 30th of this month.
To repair the hole in the ceiling?
Yes.
Okay, and you're saying there was a hole in the ceiling on the 5th or the 6th of June?
No, we had not
Okay.
determined where the leak was coming from, and we had not cut into the ceiling at that point.
So then how could they be there to do drywall work if there was no drywall work to be done?
They were coming to repair they were going to remove the damaged drywall from the area where the leak was at.
But you're saying that's not who ended up doing the job?
It is not. That's not who ended up removing the drywall to get into the ceiling. It ended up being in our fire suppression system. So we had to have a company that is licensed and able to make that repair. Premier is
So they weren't licensed to do that then?
Premier is not licensed to work on our fire suppression system, no.
Okay, so if they were there, they wouldn't have been able to fix it anyways?
Correct, that is not something that Premier would be able to do.
Okay, also, and then supposedly, was I given a 24-hour heads up? Is this in our contract to enter my unit?
Yes, yep, we scheduled everything with you guys via text.
And I denied it on the 5th, but said it was okay for the 6th?
I don't know what the date was. I don't have that in my notes, so I cannot
That's what
speak
you
to what the
just
date was.
testified, so.
It is not. I have said multiple times that I do not have the exact date in my notes, so I'm not able to speak on that.
Any further questions, Mr. Kaufman?
Will this be the last time I speak with Mrs. Cherry during this trial?
Yes.
Okay, I would like to ask you, when was the initial phone call and voicemail that you received from me in order to contact you about the issues within the unit?
I'll just object lack of foundation as some fact, not
I
evidence.
think that was already testified to, but she can definitely confirm it. Because I have it as the initial was made in beginning of June and then it was confirmed in July.
Yeah, it was June 6th was the date that she said she reached out to them to discuss the unpaid bill or
All right,
unpaid
so
bill.
she can confirm that that's a testimony. That's what you're looking for. Is that correct, Mr.
Yes,
Kaufman?
Your Honor.
So Ms. Cherry, was the initial contact to do work on the unit at the beginning of June?
Yes, yes, and that is when we began making all of the repairs and addressing all of the issues that he had notified us
And I have
about.
that initial work order was June 6th?
Correct.
Okay.
So just to clarify, you're saying that my initial calls to you were in June to report the damage in the unit?
Yes, that the beginning of June.
That was the first time you and I spoke, was June?
We had spoken one other time over the phone before I was managing City View. I was providing coverage for Aaron while he was on vacation.
That
and
was
we
in
did
April,
speak.
correct?
I believe so, yes. About your closet
Okay.
door.
Oh, the roof leak wasn't mentioned then?
No, it was not.
Do you have my voicemail from April as well?
I have a recording of the phone call where you and I spoke in April about your closet door.
Okay, and the roof leak wasn't mentioned?
It was not.
I'd like to hear that conversation.
Do you have it?
I do
I
not.
do.
Okay. I'm going to provide you the chance to present any evidence since this has been set for hearing for the last month. So,
Yeah. Yes, sir.
any other questions?
No, Your Honor.
Ms. Brown, do you have any questions of the witness, Ms. Cherry?
I guess I would like to know if your records show that I called on March 7th 3 times.
Ms. Cherry, do your records indicate that Ms. Brown called on March 7th?
I am pulling up that screen right now.
Okay.
I do show that there are 3 calls on March 7th. Those would have been to Aaron. I was not at the property then.
But there is confirmation that the phone calls were made to
Yes.
the City View Apartments or the property management system on March 7th.
Correct.
Do you have the like recording of the call? Because I don't think like that you would have answered.
So is that a question or a statement?
It's a question. Do you have the recordings of the call?
It's like we do have recordings of those.
Okay, and then on the 10th of June, do you have a phone call from me as well?
So June 10th.
Let me get to June here. Yes.
So there is an indication that in June 10th, you can confirm that at least somebody called City View Apartments on behalf of Miss Taylor or Miss Brown.
Yes, and it looks like we also had communication in writing the next day regarding the issue that they called about. It looks like contractors were supposed to be out that day, and they had a scheduling issue. So they were going to be arriving, it looks like the following day on the 11th.
Any further questions, Ms. Brown? Okay. Any redirect, Ms. Larson?
Yeah, I was gonna ask your honor, do you want me to detail out the court cost, or that was already part of the court record?
That can be a part of your summation. Yeah.
Okay, no problem, thank you. Then I don't have.
All right. All right. May this witness be excused from the plaintiff?
Yes.
From the defense. Do you have any problem with this witness being excused? Thank you for your appearance, Ms. Chair. You're all set.
Thank you.
Thank you.
All right. Any further proofs, Ms. Larson?
No, your honor.
Do either Ms. Brown or Mr. Kaufman, do you have any, you could give testimony, I can swear you in, you'd be subject to cross-examination. So you know that once you do your direct, you'd be subject to cross-examination, or do you have any evidence to present to the court? So first of all, Ms. Brown, do you want to testify? And so first, do you want to testify? Okay. Do you have any evidence you want to bring to the attention of the court? You'd have to show Ms. Larson the evidence first. And that would be something other than your testimony. And here's the problem with pictures, that they'd have to be printed out and we'd have to have something fungible to mark as an exhibit. Yeah, I mean, we could adjourn it for a couple of days for you to do it, but that just means that it's a term. This is a non-payment case, so we'd just be back as soon as we can. So understand that, okay? If you're going to present evidence, it may be problematic, especially since right now I've only heard that June 10th seems like the original date that it was reported.
Right.
Which is not, we're going to disagree with that.
Okay.
No, I'm good. Thank you.
All right, Mr. Taylor, Mr. Brown, did you want to testify and you'd be subject to cross-examination?
No, Your Honor, but I would appreciate an opportunity to bring in physical.
All right, and this is a time set for hearing, and I believe.
Your honor, I'd ask them to be able to move forward today. I haven't seen any photographs. I've spoken with Mr. Kaufman prior to today. He didn't mention any photographs.
Well, any quote photographs that the court would look at would have to be looked at yourself. A, that's one way to admit evidence. B, anything in writing, anything has to be in writing. And right now it sounds like June 10th is the date that this was all documented.
And June 6th.
And June 6th, yeah, June 6th is the original order. And then follow-up was June. There was some follow-up June 10th and into July. It looks like there was some conversations into July. So I'm not going to grant an adjournment of this. Mr. Brown, would you like to testify in regards to any testimony concerning times you met, times you spoke, because you're saying this is in dispute, and then you'd be subject to cross-examination?
Yes, Your Honor.
All right. So let's go ahead and call you up and you can. All right. So Mr. Kaufman, I'm going to have you spell your first name and your last name.
Your Honor, my first name is spelled Stephen. My last name is Kaufman.
All right. Please raise your right hand, sir. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, I do, Your Honor.
All right. Go ahead and have a seat.
Thank you.
And go ahead and you can go ahead and narrate for me you're under oath. You can tell me what happened here.
Okay, so Mr. Noyes here, Aaron, was the property manager when we moved in, which would have been paperwork on the 28th of February, move-in date, March 1st. So almost a month in, I attempted to get a hold of the front desk property management and didn't receive a call back. We were already having issues as far as pests in the unit, dishwasher not working, the bathroom sink had an issue, the garbage disposal wasn't working. And shortly after that, like within a couple of days, the weather had warmed up to the point that what we thought was a leak on the roof had started to come through my ceiling in my living room.
And when you say reach out, in what capacity did you reach out?
Multiple times I called the property management.
Okay, so none of, is any of that in writing? The law requires that you put down in what's required to be fixed in the apartment in writing. Do you have anything in writing?
No, I did not submit anything,
Right.
but there was no property manager at that point in time, and we hadn't even been there a full month. So I hadn't used that.
But you didn't use an email or anything to that effect?
No, Your Honor, just phone calls and voicemails to the property management.
All right, you may proceed.
Okay, thank you. And then so, like I said, we had started to have a leak problem in the living room, and it was right around the time that the snow was melting completely. So I think we were all at that point on the same page that that's where it was coming from. I didn't hear from property management. So sometime between when Mr. Noyes and Mrs. Cherry, if I'm not mistaken, took over his position, I didn't hear back from her until mid-April to late April. And at which point I said, hey, I've been trying to get a hold of you. I've called multiple times, left voicemail, and I have all these issues. Plus I have a leak in my roof. And this was the first time that I had spoken to her, and I wasn't privy to the fact that she was now in Aaron's position. I thought maybe something had happened to him or something along those lines, and Aaron and I really got along. So I was just more worried about him than the leak, even though I was upset about it. But then so I get a call from her, like I said, the better part of a month after I had attempted calling. And I said, hey, so, I've had these problems for over a month now. I've called multiple times. I haven't heard anything back. I said, and she was worried about the back rent. I did pay half a month's rent because I didn't want to get too far behind, assuming that we'd be able to work something out. And when I did finally talk to her, I said, all right, well, what can we do? Because I've now had a leaky roof. My dishwasher doesn't work. I've been doing those by hands. I have bugs in my unit. My bathroom sink won't stop. My garbage disposal doesn't work. And
was any of that placed in writing? The second round of discussion concerning what was not working in the unit.
If she has my voicemail message, that would be there.
Writing,
no, Your Honor.
Okay. All right, you may continue.
And so again, this is the first time that I talked to Mrs. Cherry over the phone, and I said, so what can we do? Because I've been having these issues for over a month and have attempted multiple times to get a hold of you. And she just absolutely put her foot down. There's nothing that they could do, and that I should have gone above and beyond and physically ran around the building trying to find a maintenance person, and that calling and leaving voicemails weren't sufficient. And like I said, when I started to have these issues, I hadn't even been living here a full month. I didn't know who the maintenance man was. I'd never used the resident portal that she's talking about, anything like that. And the only person that I knew by name, firsthand, by face, was Aaron, and he was nowhere at the property anymore. And I wasn't told that. So the one person that I knew was just not there anymore, and no